This is an AZ Court Help Legal Talk on Received a Traffic Ticket, Now What? Presented by Shahin Damoui of MayesTelles, PLLC, filmed in 2022. Thank you.
Okay, so today what I wanted to talk about a little bit is when you receive a traffic ticket here in Arizona, where do you go from there? And so we're going to talk a little bit about that process, about some of the options, and maybe some tips and tricks that can be helpful should this situation arise. Just a quick disclaimer before we get started. This is general information that we are providing. We cannot provide any legal advice to non-clients, and this presentation does not create a client relationship. And if you have specific questions, we encourage you to consult with an attorney of your choosing. So in Arizona, traffic tickets will come in one of two forms. If you violate a rule or regulation while you're driving, you will receive a citation. That citation will either be a civil traffic citation or a criminal traffic citation. And we're going to go through the differences and how the processes are kind of affected depending on obviously which form you're given, if you're given a civil violation or a criminal. So here we have what looks like a sample. Again, when you receive a citation here in Arizona, you're going to get exactly what looks like this. It's going to have obviously the registered owner, who you are, some of your information. And then when we look here towards the middle of the page, list the criminal charges first, if applicable. So what that means is that sometimes what you'll receive is a citation that has multiple charges on it. Some of those may be civil and some may be criminal. There can be a combination of both. And so in this instance, as you see, this particular individual was cited for an improper position for a right turn. And the way that they classify this is, as you see on the right there, that box that's checked off is the civil traffic box that's marked there. And so should it have been a criminal, obviously that would have been the box that was checked, and so forth. And then it will give you information for when you must appear. As you see here, that court date is listed, and it will also give the citing officer's name and badge number. Now, signing the citation. So anytime you're given a citation, we'll go back here and you'll see at the bottom left here is where that signature would go. Anytime you're given a citation, criminal or civil here in Arizona, you have to sign the citation. Now, what does that mean? Signing the citation does not mean you're admitting any sort of guilt. All you're saying is that you were given notice of the citation, and you know that you have this court date that you are required to show up for. There are civil and there are traffic citations, and the processes are very different depending on which you're given. And again, there may be an instance where there's a combination of some criminal and civil within the same citation. Now, with civil citations, essentially what those are your standard traffic tickets that most people think about, that usually include a fine of sorts and likely points assessed against your driving record. And so when you receive a civil traffic violation or a citation, you can respond to that in one of three ways. So if you're denying responsibility, then there will be a hearing set and heard by a civil traffic hearing officer. The finding of guilty or not guilty is going to have a preponderance of the evidence. And all that means is, since we're not in criminal court here, that citation does not have to be proven beyond a reasonable doubt. Instead, it only has to be proven by preponderance of the evidence. And if we think of it as sort of a sliding scale, preponderance of the evidence only means just a little bit over 50%. So maybe a little more likely that you did violate this violation than you didn't. If we were with criminal, and again, we'll talk about that a little more with the burden for a criminal citation or even a criminal traffic citation, that burden is beyond a reasonable doubt. And so now it's a much higher burden that they have to prove in order for you to be found guilty of said violation. But again, with civil ones, that burden is much lower. So generally, you don't need, and in this instance, it would be the state or the officer that wrote the citation. They don't need a bunch of evidence in order for you to be found guilty. Again, that burden is lower there. You have a second option, and that's just to plead guilty. And if you plead guilty, that court hearing that we saw on the citation page will likely be vacated. If you pay for the citation prior to that hearing, then there's no need for that court hearing. And again, you can pay for it by phone, mail, or in person. Now, the third option, which again, I want to heavily reiterate is always going to be your best option if you're eligible. And that's to attend a defensive driving school. So what that allows for is the dismissal of one eligible charge. So if we have a civil traffic citation that has 3 or 4 different charges on it, only one of those would be eligible for defensive driving. The other ones will not be. So for those other ones, you will either be pleading guilty or not guilty, and going through those steps that we had mentioned. Another caveat about defensive driving is that you can only do defensive driving 1 time per year. So, and again, for 1 charge. So oftentimes what you'll see is more than 1 charge on a civil traffic violation. And so ultimately, if there is only 1 charge and you haven't done defensive driving in the last year, that is the absolute most preferred thing to do, because ultimately that will not lead to any points on your record, and it will also lead to a dismissal of that charge. So when that's an option and you're eligible, that's definitely something you want to take advantage of. And so we're going to talk a little bit about those requirements for defensive driving. So again, for defensive driving, it cannot be a criminal traffic citation. We're still just in the civil realm. And you don't want to argue that you didn't do it, so you're not contesting that ticket. You're accepting the citation for what it is and accepting responsibility. You also cannot have been in an accident due to that violation that may have caused a serious injury or death. You must hold a non-commercial driver's license. So if you are a commercial truck driver or something of that sort, you will not be eligible if said violation occurred in that commercial vehicle. And again, the most important, you have not attended a defensive driving course within the last 12 months. So that's really going to be the eligibility requirements. And again, if you are eligible for civil traffic violation to complete defensive driving, it is important that you do so. You want to do it early. So when you receive the ticket and you know you're eligible, you want to call the court as soon as possible. You don't want to wait until the day before that hearing is set and try to get everything done, because it does take some time for the court to process the defensive driving and make sure that everything is there prior to your court date. So what they generally require, most courts, is that it be completed at least 7 days prior to that date. But of course, you could always call the court and ask for an extension of time to complete defensive driving, something of that nature, and they'll generally grant that. And so again, if that's something you're eligible for, you definitely want to make sure to take advantage of that. Now we're going to talk a little bit about the criminal traffic violations. And so with the criminal traffic violation, they'll either be designated as a misdemeanor or felony. You will have a court date assigned. This is not the situation where you can accept responsibility prior to, and no, you will have to show up at the first court appearance, which will either be known as the initial appearance or the arraignment, depending on if it's charged as a misdemeanor or a felony. And at this hearing, again, 2 very simple things will happen. They will read the charges against you. And again, they will let you know what the minimum and maximum is. And at that time, you will either enter a plea of guilty, not guilty, or no contest. So you're not doing any of that before that court hearing. We'll be at that court hearing. And again, it will proceed much like any criminal charge would. And we'll go in depth a little bit as to how exactly that process looks. But again, you will be required to show up. Again, if you retain an attorney, you may not. Your attorney may be able to show up on your behalf. But again, if not, you have to make sure that you're there. And at that time, you will enter that plea of not guilty, guilty or no contest. So again, when we're talking about having to appear in court, typically when you receive a civil traffic violation, you don't need to appear, as we talked about, unless you plan on fighting the ticket. So if you accept responsibility early on when you receive the citation, or shortly thereafter, and decide that either you're going to do the defensive driving before the court hearing, or you're just going to pay the fine and accept the consequences on your potential insurance premiums and driving record, then you don't have to. That court date will be vacated. However, you will need to appear if you received a criminal traffic violation. And again, we'll talk about what a criminal traffic violation is, but just some examples. If you're speeding going over 30 miles above the posted speed limit, you can be charged for criminal speed, which again is different than civil speed. And also if you're going over 85 miles an hour on any roadway, you can be charged with criminal speed. Now, a lot of those are up to the officer in particular's discretion. Just because you're pulled over going 85 does not mean that you will automatically be given a criminal speeding citation. Again, some of that is discretionary in terms of the officer and some of the other circumstances surrounding the stop itself. And you will have to absolutely appear if the citation or the alleged offense that you committed involved a traffic accident where there's been a serious bodily injury or a fatality. So this is a question we get all the time. Should I hire an attorney to represent me? Again, if you plan on disputing your ticket and fighting it, whether it be civil or criminal, it is preferred to retain an attorney. But if you're doing defensive driving and you're eligible for defensive driving, there's no need. We went through some of those eligibility requirements. And so if you receive a civil traffic violation, you have not completed that defensive driving in the last year, and you meet those other eligibility requirements, you can just call the court directly, let them know that this is what you want to do. And there's really no other steps involved there. And you can have it all taken care of without needing to retain an attorney. However, if you plan on fighting it, whether because you may not be eligible for defensive driving or because you believe that it was wrongful, that citation, then definitely it's preferred for you to retain an attorney. But again, if you're eligible for that defensive driving, that's going to be your smoothest path to putting this behind you. And also, again, if it's a criminal traffic violation, then you certainly want to strongly consider having an attorney, not only because the process is a little bit more complicated to kind of weave through as somebody who may not have much knowledge of some of these proceedings and how these violations proceed. And moreover, because the potential consequences can be fairly serious if it's a criminal traffic citation, again, and those consequences are not only limited to your criminal record and you may be convicted of a criminal violation, but also the subsequent effects that could have on your driving privileges, on your insurance premiums, points on your record. So there's a lot of factors there that make a criminal traffic violation a situation where you would strongly consider retaining an attorney. When we talk about fighting the citations, there's a big difference in how you're allowed to present evidence, what evidence is going to be disclosed to you, depending on whether that violation is civil or criminal. So if it's a civil traffic violation, there's not going to be a prosecutor assigned to this matter. So it's going to just be you and the hearing officer, that judge, and likely the law enforcement officer that wrote the citation. So you do not have, again, you don't have a prosecutor, which as defense attorneys is really our main avenue of getting the result we want is through the prosecutor. You're not going to have that on this matter. And so the courts are less inclined to cut you a break when it's just, again, you and the judge and the officer. And so the rules of evidence and the rules of disclosure are much more limited in these civil traffic violations. A lot of that's because of how common and how often these occur. They cannot just have the means of having a prosecutor assigned to these civil traffic violations. And frankly, if they had the same sort of evidence disclosure rules as they would had this been criminal, the courts would just be flooded. So that just comes down to the judicial economy. They need a way to make sure to get the civil traffic ones expedited and have a decision as soon as possible without letting it linger. Now, again, if it's a criminal traffic citation, then that's going to proceed exactly how it would if it was a regular criminal violation. If you were charged with assault or if you were charged with battery, that same process is going to occur. And moreover, the same disclosures will also be required to take place. And what I mean by that is anytime you're charged with a criminal act at all, there's going to be a prosecutor. And so same with this criminal traffic citation, there will be a prosecutor, and they are required to disclose all the evidence that they could use against you if this matter went to trial. And essentially what that includes for the most part is going to be any officer body camera, any witness statements, any surveillance camera that may be, interviews, photos, anything that again, that they would be able to use to prove that the alleged criminal traffic citation occurred. They have to disclose that to you. Again, with the civil, they don't have to do any of that. All you have is the citation. So with the criminal, like I said, it's because the stakes are higher. They're also required to disclose everything that there is in the situation. So if you have an attorney in these matters, generally something that we will do is interview the officer and any officers involved and get those statements on the record. And again, we have the opportunity to cross-examine. There's a lot of things that you're able to do if it is criminal than if it's civil. So that's why we also, strongly advise if it's criminal that you definitely likely want to hire an attorney. And again, with civil, it may not be as important to have counsel. So kind of what we talked about before, if it's a civil violation, essentially you're going to just have the judge and really the officer, the law enforcement officer will essentially act like the prosecutor. They're putting on this case. They're saying, I either observed them violate this or, essentially giving the basis for that ticket or for that civil traffic violation. And so again, they can present their own testimony. They'll generally talk about how much experience they have. If it's something involving maybe a speeding ticket, they'll give a little bit of background on if it was a radar that picked you up speeding, or if they paced you. And so they'll give that kind of foundation. But really, it's going to be you presenting your story, and then the officer stating their story, and then the judge will make that decision. And again, just to reiterate, at that setting, the civil traffic setting, that burden of proof is low. So the officer doesn't need a smoking gun, so to speak. And oftentimes judges will take them at their word if they don't have any accompanying evidence. So it's more difficult in terms of from a criminal defensive lawyer perspective, that your hands are tied a little bit in these civil traffic citations. So this is a question that we get all too often. Is it worth paying the traffic ticket and taking whatever consequence comes, or to go to court and fight it? There's some things that you want to consider in making that decision. Obviously, the points on your driver's license, whether there's a potential license suspension and revocation, involved with the violation. And essentially what that means is that anytime you have either, again, it could be civil or criminal traffic violation, you're going to have hearings with the motor vehicle department, or not necessarily hearings, but you're going to have to not only either fight or accept responsibility in court, but you're also going to have some repercussions from the motor vehicle department that are completely separate from the court. The court may issue fines, the court may issue whatever they feel is deemed fit, but now you also have the motor vehicle department that will likely impose points. Almost every moving violation, civil or criminal, is going to have points associated with it. And we'll talk a little bit more about how that works. And again, that's separate from the court. The court can still decide to have their own consequences as well. And you will have fines. That's just a given. Again, something to consider are the fines too excessive. And another big concern for people is the increase in car insurance premiums, and knowing how long that those increases will last, depending on the severity or the nature of the violation that you've received. And again, everything becomes much heightened and the stakes become much higher if that citation is for a criminal traffic violation. And we will go a little bit more in depth about that here. So points on your driver's license, as well as license suspension and revocation. As we stated, if you plead responsible to a traffic citation, the Department of Motor Vehicles may and likely will incur additional penalties against you as the driver, depending on the severity of the ticket and violation. And again, this is separate from the penalties enforced by the court. In Arizona, every time you're convicted for a moving traffic violation, and all that means is that the car is in motion, points are going to be assessed against your permanent driving record. The important thing to note is if you accumulate 8 or more points in a 12-month period, you may be required to attend what's known as traffic survival school, not defensive driving. Important to remember that they're not the same thing, or your driving privilege may be suspended up to 12 months. We're going to talk a little bit about how many points come with certain violations, so that you can kind of get an idea for what it takes to accumulate 8 points in a 12-month period. Now, when we're talking criminal traffic violations, those points are going to be heightened. So you're going to have more points assessed to your driving record. And depending on the severity, your license may be suspended or revoked, regardless of if you have even less points. So you may only have 2 points on your record, but this criminal traffic citation was severe enough that automatically resulted in a suspension or revocation of your license. You're not eligible for defensive driving for criminal traffic citation, as we mentioned earlier. And again, with the criminal traffic citations, in addition to the fines and points, you can anticipate additional fees, potential community service, probation, and or potentially jail. So this is where we're talking about the points assessment. So for DUI, 8 points. What that means is with any DUI, you will likely have an automatic suspension. They can range from 90 days to a year. And again, there are different levels of a DUI. And so that's going to play a major role, whether you were from 0.08 to 0.15, if you were from 0.15 to 0.2. So like I said, there's going to be levels to it that are going to have their own point assessment, as well as those other consequences we talked about. Now, reckless, aggressive driving, leaving the scene of a hit and run, as you can see, these are all 8 points, meaning, again, that this violation in itself will come with that 12-month suspension if traffic survival school, again, not defensive driving, is not completed. And then we see some of the ones that have some less points: failure to stop or yield causing death, failure to stop or yield causing serious injury at 4 points, speeding at 3 points, driving over or parking in a gore area at 3 points, and all other ones are going to be 2 points. So really the top 4 are going to be really the most consequential. But again, even if you rack up a couple of these less severe ones, you're going to be over that 8 points. So when we talk about license suspension and revocation, Suspension just means a temporary removal of your driving privilege. This can be done two ways. Again, you rack up those 8 points we talked about within 12 months, and you'll get a suspension. Or if you commit certain criminal traffic violations, and that comes with an automatic suspension. And so that, even if, as we talked about, even if your points aren't at 8, that'll come with an automatic suspension, regardless of what your points are at. So that first one is racking up 8 points in the 12-month period. So again, you may first be required to attend that traffic survival school. Again, if that's separate than defensive driving. If you fail to complete that in time, your license may be suspended for up to 1 year. So it's very important that you are aware, and if you've gotten a few seemingly minor violations or citations, you just need to be aware that they add up, and those points add up. So you want to be very clear as to where you stand on your driving record. So now, committing certain criminal traffic violations. So certain criminal traffic violations can result in your driver's license being suspended from days to years. And in some instances, it could even be revoked. And what revoked means is essentially it's going to be a suspension for a long period of time, but potentially indefinitely. With the revocation, if, for example, they give you a period of 1 year, generally for revocation, it'll be more. If they give a 3-year revocation, that doesn't mean after 3 years, your license is now reinstated. No, that means after 3 years, you have to then complete all these requirements to then get your license reinstated. So it's kind of a 2-part process. Is first, you'd have to wait out whatever period that is. And secondly, then there's a whole process of getting it reinstated. It's not just now that time has expired, you're good to go. No, that's not the case. Some of these criminal traffic violations, especially these 4 that I've listed here, are going to require that traffic survival school, which again, I know I've probably said 2 or 3 times, is separate from defensive driving, but it can get a little confusing, and the requirements can be similar. And so it's just very important that you don't confuse the two. So with the traffic survival school, may be required for some red light, running a red light, depending on the circumstances. Oftentimes those will not be criminal. Aggressive driving will likely be criminal. A moving violation that results in a serious or fatal injury. So what that means is, obviously, if even if it's a civil violation that you violated, but somebody ends up dying or having a serious bodily injury, that's going to elevate that now to a much higher status that will require traffic survival school. And they will require traffic survival school for your first moving violation when you're under 18. So again, it's they take it very seriously, especially on the younger drivers. So like I said, if you're involved, if you're 18 or under 18, so essentially 16 or 17, it may be in your best interest to look into retaining an attorney if you are charged with that moving violation, because you would have to complete some of the traffic survival school requirements. So these are some criminal traffic violations that may have suspensions, may come with suspensions just from the violation itself, not from the accompanying points. Now, again, the points can bring something that's not generally a suspendable offense, can bring it into the realm of becoming a suspendable offense. But these violations on their own, without considering the points, will lead to a likely suspension. So that's going to be driving under the influence, reckless driving, and aggressive driving. Now, when we talk about revocation, so that's the longer period of likely over a year, and having that process of having to get it reinstated. Now, these are some violations, criminal violations that may come with that possible revocation. So a extreme DUI. So when we were talking about levels of DUI, the extreme is not just going to be that you're above 0.8, to 0.15. So if you're above, 0.12, or excuse me, a 0.02, at that time, then you may be into that extreme DUI realm, where obviously the consequences are much higher, and will likely come with an extended suspension, if not a possible revocation. An aggravated DUI, without getting into too many details, is a DUI with some aggravating circumstances, and those can be a number of different things. You may have had a child in the car. You may have, like I said, not going to go into any possible or every possible scenario of an aggravated DUI, but that's, again, it's not just your boilerplate DUI. There's something else that makes it more severe added to it. Hit and run is a big one, and it happens often. And so it's important, and to keep in mind, any sort of insurance premium that, it's never worth leaving the scene of an accident, because those penalties are really severe. Not only the criminal liability, but the insurance liability, the points on your record. Again, that's one that they've really emphasized. A felony in which a vehicle is used. So, like I said, this may not be limited to just the operation of the vehicle itself. You may be trafficking in a vehicle, trafficking narcotics in a vehicle, and so that will likely come with a revocation. Again, the moving violations resulting in death that we spoke about. You may ran a red light, hit a pedestrian and died. You may, hit another car and the passenger died. So those will have extended suspensions and possible revocations. 2 or more convictions of DUI, reckless driving, or racing on the highways. Have multiple DUIs in a relatively short span of time, in a 72-month period. Every subsequent DUI not only can be charged more severely, if you get to your 4th DUI in 72 months, there will be charges as much more severe felonies, but also reckless driving and racing, which has been a big issue recently as well. So these are basically the most severe type of criminal traffic violations that you can incur, and those will come with again, the possible revocation, as well as all the other consequences we talked about from both the courts and the motor vehicle department. So now we want to talk about, how do we appeal a traffic court decision? Again, it's important to note, you can't appeal a civil traffic violation. You can only appeal a criminal one. So the same exact process that you would go to for if you were to appeal a charge of, assault, it's going to be the same that you would go through for a criminal traffic violation. So again, the very first step is receiving that final order or judgment, meaning you were found guilty in having violated that criminal traffic citation. Again, without getting into too many of the weeds, essentially what you will have then at that time is you file a notice of appeal. We'll go in a little bit in depth into these processes individually, but again, the most crucial is that notice of appeal, because when you receive that final order, essentially finding you guilty, you're going to only have a limited amount of time to file that notice of appeal. And if you don't, you've lost that chance. Step 4, you have to pay a record fee. What that means is that you have to obtain a record transcript of your actual case in step 1, where you were found guilty. And you would obtain that from the superior court. Now, that record fee oftentimes is fairly high and again, when I say that, I mean, in considering whether or not it's worth appealing, that's something to consider, because the fees associated with appealing, just the record fee itself is going to be around $200, $300 just to get that record. There'll also be an appeal fee, which we see in step 7. And so you really have to consider if there's merits to your appeal before going through these steps, because like I said, it will have, it's not going to be cheap. And it does take some steps, like I said, and especially if you're doing it on your own without an attorney, these steps have to be completed, exactly as we state, or else it will not get to where it needs to go to. It will be dismissed without even being able to actually consider it on the merits, because if you didn't file it correctly, whatever it may be, those will just lead to it being dismissed, and then you've lost your chance. So it's very important that if you want to appeal and you believe that there's a basis for appeal, that you follow all the steps exactly as they state. And again, we'll go through those here briefly. So when we talked about with these notices of appeal, as they look something like this, you'll receive, and again, it just says, here's my address. I'm intending to appeal this decision. There are two separate stages for the criminal appeal process. So again, that first step is going to be in the municipal or justice court, meaning where you were found guilty, where they said you were responsible and they gave you the fines and everything involved. That's where the first step of this is going to occur. But the second step will actually take place in the superior court of the county in which the citation took place. So for example, if you were given a citation in Phoenix, you would first go to Phoenix Municipal Court. And if you're found guilty at the hearing in Phoenix Municipal Court, then the second stage of that will take place in Maricopa County Superior Court. And so that's the way that will fall. And we'll go into some of the details as to how that exactly occurs. And again, you must complete stages, or you must complete all the steps at both stages, or you run the risk of having your appeal dismissed. And more importantly, you'll have it dismissed without them really being able to consider it on the merits. So what that means is there may have really been, an injustice. You were found, guilty without cause. But if all of those requirements that we talked about aren't completed in terms of the filings and the fees, they won't even be able to consider that. And so again, it's very important. We talk about that stage one when we're still in that municipal court. When you get that order or that decision that says you're found guilty of this citation or of this violation, within 14 days of that date, and again, that's calendar days, not business days, you must file that notice that we talked about, that notice of appeal. And all that is a single sheet stating essentially that I intend on appealing this decision. Now, the second step, which we talked about, is within 14 days after you file your notice of appeal, you have to arrange to pay for a copy of the proceedings. We talked about it a little bit. You have to pay for that transcript of the proceedings that occurred in the municipal court. Again, if you fail to pay for that, your appeal will be dismissed. And again, they have some waivers if you really have some trouble affording it that you may be eligible for. And the next step we move on to is essentially, this is going to be the crux of your appeal. You're the appellant if you're appealing a decision. And what step 3 is essentially a written explanation. In legal terms, I'll call it a memorandum of why you believe the decision was wrong. Why you were not actually guilty of this. Now, the courts all have very strict requirements that it has to be typed or printed on letter size, must be double spaced, can't be more than 15 pages in length. And what's important about that is if you intend to include, for example, an exhibit, meaning a piece of evidence that may help your actual case, and you want to attach that to this memorandum, that is not counted against the 15 pages. So 15 pages is the written memorandum, and then any accompanying exhibits can follow without going against the length requirement. Now, that memorandum must be filed with the court within 60 days of the deadline to file the notice of appeal. So this is where the dates become really important, because it's a little tricky to remember everything. You have 14 days to file the notice of appeal, then another 14 to pay for the record and obtain that, and then 60 from filing the notice of appeal to submit your written memorandum. So again, this is why I say it's very, very important to make sure that all these steps are done exactly as stated, or else you run the risk of having it dismissed without them even being able to really consider it. And once they've received your memorandum, they'll let you know that they've received it. And at that point, all you do is wait for instructions from the Superior Court. You're done with the municipal justice court at that time. And then we move on to the Superior Court, which is stage 2. So if you've done everything the way you're supposed to do in the first stage, your case will move to the Superior Court, where an appeals judge will look at the case. about 60 days, which is generally the safe bet in time. About 60 days after you file that memorandum, you will receive a notification that your case has been sent to the Superior Court, and you'll receive a second notice assigning a court case number, telling you who the judge will be, and essentially telling you what the next steps are. Generally, what they'll also let you know is that the state, if you will, which would be the prosecutor in this case, can file a response to your written memorandum, and all that generally means is if they believe that your memorandum is, if you're incorrect on things, or if they object to some things that they think may not have been accurate, or whatever they want to say in terms of saying that you were convicted rightfully, they'll put in this response. So now the judge is going to have your written memorandum, the state's response in front of them to consider. So what will happen is he will look at both. He will also look at the record, which you've already paid for in step 2, and he can do one of 3 things. He can affirm the trial court, which means he's essentially saying the trial court didn't get it wrong, and again at that point, then you lost, and that's going to stand. That citation or that conviction will stand. He can overrule and obviously say no, you were done wrong, and I'm ruling that be dismissed, in ruling in your favor. He doesn't have to either entirely rule for you or entirely rule against you. So there are some parts, and again, when we talk about some of these criminal traffic citations, you'll have multiple charges. So he may rule on certain charges in your favor, other charges not in your favor. So they're able to break it apart and make rulings on individual pieces, as well as the matter as a whole. And you can also modify, potentially either the consequence or modify a part of it. So they have real broad discretion as to what they can do. And if it's not clear, if there's still some questions as to whether or not the judge believes that you've made a compelling argument, or the prosecutor has, they'll likely set it for a new trial. And this is something that they'll do, probably, I would say, aside from just dismissing them, they'll generally opt for the new trial as opposed to overruling the trial court, because that allows them to, in a sense, give that opportunity. You have that opportunity to be heard in a new setting now. But again, that's also going to be up to this new judge now that you're going to, it's going to rehear it. They're going to have the same record. And so, again, obviously the best possible scenario is that they just dismiss and overrule the trial court, but in an abundance of caution, more likely they will set it for a new trial if they have any sort of, questions or concerns on either side. So that's kind of their safe bet, is setting it for a new trial. And obviously if it's set for a new trial, and then that's exactly what will happen is you'll have that same trial that you were initially found guilty on, you'll have it again. And at this time, like I said, if there's new evidence, whatever it is that you want to submit to bolster your previous shot that you had, you're obviously able to do that. And finally, last thing I want to talk about is setting aside a traffic citation. So without getting into too much of the crux of it, states will either allow a person who has been convicted of a criminal offense to set aside a conviction if certain requirements are met, or to expunge if certain requirements are met. States will not allow for both. It's either or. In Arizona, they're a set-aside state, meaning that that individuals who have completed their sentence, and what that means is when you're convicted for something, there'll be a sentence can be as little as a fine. It could be as, community service. It could be a combination of things. But once that's completed, you can apply for this set aside to have these prior convictions set aside. And essentially it's Arizona's equivalent of an expungement However, it is not deleted from your record, and that's a very important caveat. It will still be on your record. However, in the disposition, as opposed to stating, guilty, it'll just state set aside. So again, the disposition will change, but there's no instance where that record is deleted or sealed in any manner. Speaking about the eligibility a bit, only, as we mentioned, certain criminal traffic citations are eligible for set aside. But even within criminal traffic citations, a lot of them are not eligible for a set aside. Frankly, the majority of them are probably not eligible for a set aside. And again, the ones that are excluded from being set aside, meaning you can't have it set aside, are driving on a suspended license, criminal speeding, felony flight, aggressive driving, and hit and run. So obviously, the big one that you see is not on this list, meaning you are eligible to have it set aside, is DUI. And so a lot of people opt to go that route once they've fulfilled their sentence. And so when can you apply? So again, only for criminals, certain criminal convictions. And if that conviction was a misdemeanor, once you've completed the terms and conditions of your sentence. And again, for criminal traffic citations, the majority of them are going to be misdemeanors unless they get to that aggravated, an aggravated DUI or some offenses that may have occurred, that may have resulted in a death or serious bodily injury. But essentially for misdemeanors, once you've completed all the terms and conditions of your sentence, and that can include, for some DUIs, they may include an interlock that has to be on your vehicle, a fine, attending alcohol classes, attending a victim panel, as well as a term of supervised or unsupervised probation. So you'd have to wait until all that is done before you can apply for the set aside. Now, if you were convicted of a class 4, 5, or 6 felony, you have to wait an additional 2 years after you've completed everything. And finally, for class 2 or 3 felonies, which are obviously the most severe, 5 years. And again, we're talking at least. So once you've completed absolutely everything that you're supposed to, add 5 years, and then you can apply.
Again, I am Shahin Damoui with the firm MayesTelles, and this concludes our talk on receiving a traffic ticket. Thank you.